Hi there, I'm Seb Maley, and in this video we're going to be taking a quick look at the process of an IR35 inquiry and what contractors should do if they are unlucky enough to be on the receiving end of one. I'm aiming this video at contractors, and you might ask why. After all, from the 6th of April 2021, all responsibility and risk moved away from contractors and to the clients and agencies that engage them. Well, as I've said in previous videos, there is still a level of risk. Firstly, the legislation has an exemption for clients who are classed as small companies. You can find the details of exactly what a small company is on our website, but any contractors working for one will still fall under the old IR35 rules and be responsible and liable for their status. Secondly, HMRC can and do mount retrospective investigations. Under normal circumstances, they can go back 4 years, which means the period prior to the 6th of April 2021 is still very much open for them to probe. Indeed, we are still regularly picking up new inquiries on behalf of contractors into that historic period. So it's important that the change in rules doesn't lull contractors into a false sense of security. And we'll have a quick look now at what to look out for and the potential pitfalls involved in any compliance activity. An inquiry will almost always open with a letter from HMRC, so it's always important to be alert to any correspondence you receive. Typically, the letter will refer to a check of employer records, but it will be fairly clear from the content that HMRC are looking at IR35 in particular. Sometimes inquiries or checks can stem from a different check, and HMRC will often use a routine process to get their foot in the door to quickly move on to status-related questions. In some cases, it will be more direct, and they may have received some form of intelligence from elsewhere which has pointed them in your direction. You may remember that in 2019 we saw hundreds of letters sent to contractors who worked for GSK, and in that case, HMRC stated that they believed the contractor was inside IR35 in the opening paragraph of the first letter. In most cases, it's likely that the opening letter will also contain some questions and some requests for information. HMRC like to get hold of things like contract schedules and invoices from an early stage, and they're also likely to want a high-level description of how you work and what you do. Now, our advice to contractors has always been to seek professional advice at this stage. We've had numerous instances of contractors who might not be au fait with IR35, innocently responding to the opening letter and inadvertently causing a problem by using wording HMRC have then used against them further down the line. If you have insurance, now is the time to report it to your provider so they can pick up the reins. If you don't, try to find a company who have practical experience in dealing with status cases as quickly as possible. Once the initial response is submitted to HMRC, they will then come back with more questions. Now, don't expect anything to happen quickly. It could be several weeks between letters, and an inquiry can take months or years to run its course. When you do get HMRC's response, it's likely that they'll want a lot more information. It's pretty common at this stage for them to send a very long and detailed list of questions for you to answer, covering every aspect of how you run your company and how your services are provided. Again, it's really important to treat this with a huge amount of care, as the questions are likely to be leading, and a lot of IR35 is about terminology and semantics. I'd reiterate that this type of questioning is best handled by an expert who knows how the facts should be presented. Either in this letter or in subsequent correspondence, HMRC may well request a face-to-face meeting with you. You're under no obligation to do this, and we'd always suggest that all questions are better dealt with in writing, where you can be sure that you are responding clearly and accurately. Once you've provided all of the information that HMRC have asked for, and if they don't accept at that stage that you are outside IR35, it's highly likely that they'll want to speak to your client. This is often a bit of a danger zone in any IR35 investigation, because there's always a risk that it'll end up with someone who doesn't understand IR35 and may not have any direct experience of how contractors work. We would always try and preempt this risk by getting in touch with the client ahead of any contact from HMRC and ensuring that any responses are coordinated and reflective of the actual facts. After all of this toing and froing, HMRC will eventually state their final position. If they agree that you are outside IR35, then that will be an end to the matters and you can breathe a sigh of relief. If they don't, they will state that they think that IR35 should apply and will raise what is called an assessment, detailing the tax and national insurance they believe is due. This can obviously be a significant amount, but if the contractor doesn't want to take the case any further, they can accept HMRC's decision and try to negotiate a settlement amount. You do, however, have 30 days to appeal the decision, which will take the case out of HMRC's hands and to an independent tax tribunal. We've seen a lot of cases go this way over the last few years, and it means an impartial judge will review the entire case and decide whether HMRC have made the right decision about your status. To do this, they will dig out decades worth of case law and compare the facts of your case against precedents that have been set in the past. It's a common theme, but none of this will happen quickly either. There will be a very long wait for the case to be heard, and then another wait for the judgment to be delivered. It will often be several years between the opening letter and a tribunal result. In a lot of cases, the judge has rejected HMRC's position and agreed that the contractor is genuinely outside IR35. But given the complexities and long history of status, it's always a bit of an unknown quantity. If the judge agrees with HMRC, then there are several more stages of appeal, but obviously at this point the legal costs for representation will also become a consideration. The good thing is that you have, if you have representation from the start, most cases are closed down long before you get to tribunal, and HMRC often choose to pick their battles. Our advice to contractors is to be prepared, even if the chances of investigation are relatively low in the whole scheme of things. It's a good idea to have insurance or representation lined up and to collate as much evidence as you can that backs up your position. We can obviously help with all of this, so please get in touch and have an initial conversation with our experienced team of IR35 experts. Our website has tons of information and resources about the legislation, and you can subscribe to this channel for more regular video updates. Thanks for watching, and we'll see you next time.